I'll be your chair for this session. My name is Delphine Misonne. I'm an academic here at UCLouvain, Saint-Louis, Brussels, environmental lawyer and head of a center called Allezard, dedicated to environmental law and policies. The best way to crack a system, a closed system, is certainly to go to the court and to raise questions outside the usual bubble. Litigation is a very important tool in all environmental domains like climate change, ambient air, and pesticides. It is the opportunity to displace the debate to third party, not involved in the usual discussions, and to test the possible legal means besides sometimes tricky procedural questions on how to access the court. It's always important to test the legal means even beyond what you would think is the most normal pathway. For instance, we are dealing about EU law, but with litigation, why not to test habitat law in relation to impact assessment and pesticides, for instance. The lawsuit also brings creativity into the subject matter. So that's what we'll discover together, because we have a session dedicated to pesticides litigation before national and EU court. It's happening indeed today at national level, but also before the Court of Justice of the European Union. And we can thank, of course, people in the room for very important lawsuits that were brought recently to the fore and could gain really interesting advances in that area. But we are of course, constrained by the time, and so I will directly give the floor to our first speakers, a team coming from Wageningen University in the Netherlands, and for speaking for the team, we'll have Edwin, Alblas, and Emma Turkenburg presenting their thought on judging pesticides, framing illegality or legality of pesticide use in Dutch litigation. So you have the floor for 15 minutes.
Perfect. Thank you so much. It's such a pleasure to be here today to present our topic. We have a team. It's quite a big team. It's a combined of communication scientists, including Emma and Sophie, who is joining from home. And lawyers, including Louis Kotzé and myself. And we have one person bridging those two worlds, Vincent, who is both in law and in communication science. Yeah. So the starting point of our presentation is this idea of pesticides as a symbol of polarization. This is a quote that's probably very familiar to a lot of you. It was when the sustainable use of pesticides regulation was withdrawn by the Commission. Ursula von der Leyen said that it had become a symbol of polarization. And we need a new direction that is more focused on dialogue instead of new rules. And a lot of this was fueled, of course, by this famous image that you've seen if you live here in Brussels. We've seen similar things here in the Netherlands, where we are from. There's been a lot of calls for increased regulation by citizens, for instance, and NGOs. And this has been witnessed or like a response from farmers with a lot of protest. So what the government said in turn is, again, there's a need for more dialogue. People have to start talking to each other. But a lot of people think there's not much to talk about because farmers say we don't want more rules. Citizens say we want more rules and they cannot find each other. And then we have this situation that we call a regulatory gridlock, where the government says, okay, then we don't know what to do either. We have all these testing procedures. They all say that pesticides are totally safe. So we keep it in the scientific sphere and we're not going to intervene as a government. So that's the situation that we're in. Now, of course, citizens, as they often do, they didn't stop there. Instead, they started taking court cases. And what we've seen that we think is very interesting is a selection of cases where citizens brought cases against farmers for the using of pesticides to grow lilies in their local proximity. So here in orange, you see this is a lily field, and the purple is people surrounding that lily field. And they said, although these pesticides are legal by law, they're authorized, we think it's not safe. We see all these pesticides on the trampolines when the kids are jumping. We see all of these gaps in the regulatory system. We don't think it is safe. We want a ban on the use of pesticides. So farmers can still grow lilies, but they cannot use the pesticides to do it. That's what the citizens asked. And what was very unique is then that the judge responded by saying, in this case in 2023, that they agreed that the pesticide should not be used for growing lilies. They made a balancing of interest between the weight of the health interest of the local citizens and the economic interest of the farmer that wants and can make a lot of money by growing lilies, because it's a very profitable crop. And the balancing of different scientific dimensions, so like these regulatory gaps, for instance, about cocktail effects, local proximity of the citizens. There's vulnerable populations there, like the elderly and kids. And the judge said, this was in a preliminary reference proceeding, so it's a very short time span, just based on the two parties there. The judge said that taking all of that into account, this farmer, in this specific case, for this plot, is not allowed to grow, cultivate lilies for this year if he wants to do this through using pesticides. As you can imagine, this sparked a lot of interest from other citizens who also live very close by to lily fields. They thought maybe we can also start a case. So since then, there's been quite a few cases. Oh, now we have, There's been quite a few cases with similar parameters where the citizens live very close by and they want to challenge the use of pesticides for growing lilies next to their homes. And we see very diverging outcomes by the court, very different weighing of different scientific information. So for us, this is very interesting, of course. So we saw in one case that there was a complete ban on pesticide use. In that case, the farmer was simply not, they were not going to grow lilies anymore, because you need a lot of pesticides to grow lilies. In another case, there was a partial ban, because in that case, the grower said, we are already minimizing our use of pesticides, and we're only going to use 4 or 6, and we're going to use it this many times. And then the judge said, well, that looks quite good. That seems reasonable. So they said, you can grow lilies, you can use pesticides, but only the ones that you have proposed yourself. In another case, there was no ban at all, because the judge said the lilies are already in the soil. There would be a lot of economic losses for the farmer. So there the farmer can just go ahead, do what they wanted to do anyway. In another case, partial ban, they could only use biological pesticides. So we see a lot of diverging outcomes, and the reasoning is quite interesting because of how they use and how they weigh different interests, how they weigh different scientific evidence. So this really intrigued us. And then beyond the legal sphere, we thought this is also really interesting in the way that it frames risks, that the different parties frame risks, that they frame scientific evidence, what pesticides can do and whether they should be allowed or not. So beyond the legal characteristics, we also thought from a communication science perspective, it's really interesting to map in more detail what is happening here. Also because these court cases, of course, make their way outside of the courtroom. So here you can see this court case only bound the parties in that specific conflict, that specific lily field, but it did make all the newspapers, right? So it does set a precedent. It sets a new, different kind of direction. So that's what we're very interested in, what is happening here. And the main line, although there's different outcomes, the main line that we see is that courts no longer take the approval of pesticides for granted. So the farmers will say, I use the pesticides and they are all legal. It's totally legal to do this. They've been authorized. EFSA is amazing. The Dutch agency is amazing. And then the judge says, well, taking all of this into account, in the opinion of the interim relief judge, the fact that the plant production products, they do call it plant production protection products, again, a type of framing, of course, have been approved by EFSA and the CJEU, that's the Dutch testing agency, is insufficient to assume that there's no risk of neurodegenerative diseases for local residents or development disorders in the children. And then the judge said, because that those diseases are so serious, so severe, we're going to take action here and not going to allow it. So they don't take the approval for granted anymore, recognizing several regulatory gaps. I think when we both click, it doesn't work. So you're clicking, or? No. Oh, you're not clicking. Oh, I should just click more. Okay. So why are all these cases? Why are all these cases about lilies? Lilies is a specific type of crop that requires, if you want to do it in the way that it looks very nice to sell in the supermarkets and export across the world, you need a lot of pesticides, a lot of different types of pesticides. If you would compare it to, for instance, the growing of wheat, the crop to make bread from, it would be about 10 times the amount of pesticides that they use just in the span of a few months. I'm saying this wrong. They use in a few months the same amount of pesticides as you would use in 10 years for growing wheat or other similar crops. There's also been quite an increase in lily production because it's so profitable. So a 12% growth in lily production between 2014 and 2024. A lot of citizens are very concerned. So they might have lived next to a land where cows would be grazing for years, and then a farmer buys that land and they would start growing lilies. So it's very tricky. And the proximity is a huge issue. So often it's very, very close. And in the Netherlands, we don't have a lot of clear rules for how close to residents you can do this. There's rules for how close to waterways you can grow, for instance, crops that need pesticides, but not for these kind of sensitive actors. So that's why it's all about lilies now. And I think that this has also been a bit of a test case. So there were NGOs backing the citizens in the cases, providing legal advice and all. I think this has also been a bit of a test case because lilies are so extreme. It's also a luxury crop. We don't eat lilies. So that changed the dynamic. And this was also picked up in court a few times. So what we see now is that the former reasoning where they would say, okay, it's legal. A farmer could say it's legal because EFSA says it's authorized. And the Dutch national authority says I can use it this many times, so what I'm doing is okay. What is very groundbreaking here is that the judge then now very clearly says it's not okay just because EFSA and CTGB allow it. So it's no longer just simply authorization means legality. But what then means legality or illegality is still very unclear. So what we try to do is try and map and understand in much more detail through our combined interdisciplinary analysis what are the arguments and lines of reasoning that now determine legality or illegality of pesticides in these specific cases, hoping that will also allow us to draw further conclusion or analysis, at least for other crops and other types of pesticide use. So I will now move the floor, I think, to my colleague, Emma, from Communication Science.
Yes, so what we've been doing specifically is we've been looking at this a bit from the angle of framing, because we think, okay, understanding what shapes this court decision and what shapes the legality or illegality of pesticide use in these cases requires a bit of a closer look at how pesticides are understood and discussed in these cases, because we see some differences there. So we look at framing, which is how something is interpreted and how the specific interpretation is expressed in communication, because different frames can make different understandings of a problem and different views of information more salient or less salient by highlighting certain things or highlighting other things a bit less or promoting a certain interpretation of something. So what frames do is they offer a specific lens through which we can interpret or view an issue. So that's what we look at, and we look a bit more specifically at how frames can shape different definitions of a problem, different causal interpretations, so who or what is really the cause of the problem we have defined here, the moral evaluation, so which values are invoked, which interests do we find more or less important, and which actions or solutions are proposed. And we specifically look at this in court for these Lily cases, because we believe that litigants and judges may... draw on these distinct frames in their reasoning, and that their reasoning may reflect these different frames, and that they can guide what is seen as relevant, important, or persuasive in court. And by examining these frames and really mapping what is going on, we think we can identify the reasoning patterns and understand the lines of argumentation a bit better, and that way reveal how the legality and illegality is constructed differently across these cases. So what do? We take a bit of a... Yes? an interdisciplinary approach, which has been a really cool adventure to embark upon, because we all use sort of slightly different languages and terms and concepts. So it's been really nice to figure that out together in the theme. So we integrate legal analysis with some techniques from communication science, and specifically we've done a qualitative and inductive qualitative analysis of these 6 Lily cases that Edwin just talked about, to gain some more systematic insights into the frames that are competing or sometimes complementing each other in court. Now, what does that look like? This is a bit of an illustration, but what we did is 3 rounds of coding. We take inspiration from grounded theory a little bit, which means that we take these cases. We first do a round of open coding, and a lot of credit goes to Vincent here. That should be emphasized, to really go through these cases very systematically and sort of memo or paraphrase each claim and each argument that's in there individually. And then in the second round, these individual codes are grouped together to see, like, okay, what are sort of all the individual arguments grouped across clusters and themes? What are all the different points being made across all these cases? And in the last step, which we call selective coding, we look at central overarching frames. So we look at all these arguments and we think, like, okay, which sort of unique problem definitions, causal interpretations, moral evaluations, and solutions can we identify here? So this whole process led us to 4, we think, overarching frames, but it's a work in progress, I should say. So we're still sort of fine-tuning things. Click, yes. So there's 4 central frames. For the sake of time, I won't go through them all, but we can discuss them all later. But there's 4 different frames with those different characteristics. And I have some examples and quotes, but for the sake of time, I'll go through them very quickly. What we see is, first of all, pesticides use can be framed as a public health hazard. That's something we've seen a lot, where the focus is really on the fact that people are involuntarily exposed, and that health outweighs all other interests. So instead of saying it's approved, so it's safe, the main line of reasoning is there's at least uncertainty, so there should be caution, and there should be changes or actions being taken. And I'm going to skip the quotes a bit, looking at the time. But we can get back to them later, of course, because the second frame we identified is less focused on farmer versus resident and the individual responsibilities there, but more on systemic regulatory failure. So really systemic flaws, shortcomings of government, and that the problem is those structural flaws, that there's a responsibility of institutions to really protect public health. This is then used to also sort of legitimize this judicial intervention, despite the fact that there is approval for the products used. A bit countering that is the frame of pesticide use as a regulated and legitimate practice, which is really building on, okay, it's allowed, so we should assume it's safe. That's sort of another line of reasoning in there. And from this frame, trust in institutions and procedures is really stressed a lot. And here, uncertainty also has a different role. So here, the argument is, okay, there's uncertainty, so the harm is not proven, so we shouldn't take any rash decisions about this. There's also a lot of critique here on the fact that there is judicial intervention and that it turned into a normative issue, which, when some people think it's more of a technical issue. The last one is a focus more on pesticide use as just a legitimate agricultural practice. So really, okay, this is normal farming business and we shouldn't interfere. There's economic risks for farmers. These farmers, they follow all the rules, so it's unfair to put them at economic risk, basically. And I really, for the sake of time, will skip through this very quickly. 2 minutes. And what we see throughout all these frames, so these are sort of the 4 main lines of reasoning we see coming back, and sometimes they weigh a bit heavier, and sometimes they're a bit more on the background. What we see is there's a really key role of uncertainty. So different approaches to uncertainty across these different frames really lead to a different weighing of interest. So where in one case we see that there's a health risk for residents, but it's uncertain, it cannot be fully estimated, and the grower has already taken a lot of measures. This means that the grower's interest outweigh the residents' interest, and in another case we see the exact opposite. There's uncertainty in terms of health risks, so the interests of residents outweigh the grower's interests. So it's interesting to see how these different different arguments are constructed and how different things are given more weight than other things. So some key takeaways before I hand the floor to Edwin for some final words. Here are that these legal judgments, we see they reflect these sort of deeper tensions, which can be normative, epistemic, but also institutional. And we see this along these 4 different frames. So health has a more focus on regulatory failure, or in contrast, the fact that it's authorized, and more the routine agricultural practice. And what we've tried to do is to really show, okay, what arguments are made and how is this problem defined by different people? Because if you don't define the problem in the same way, it makes a lot of sense that you end up with different conclusions. And this also highlights how these courts navigate these key tensions between protection of health, protection of economic interest, agricultural viability, institutional distrust, scientific information. And there's a lot of different moving parts we found, and it's interesting to see how they are used.
Thanks. I'll round up super quickly. So our whole kind of take here is that now courts are taking such an active role in deciding on the illegality or legality of pesticides. Everything is possible, whereas before it was always, in this whole process, in the gridlock, government would always say, EFSA says it's safe, CTGB says it's safe, and now it's like, but when is it safe? How are the different interests weighted? And I think that's very, very important to look and study more closely. Some impacts beyond the individual cases. So as I said, if the judge bans the use of pesticides for growing lilies, it applies to a specific plot. So the next year, the farmer might still be allowed to use the pesticides unless they take another case and they win it again. But still, we see a lot of impact beyond these cases. So we see that there's an increased sense of urgency amongst farmers to, again, have better contact with their neighbors, because there was a lot of frustration among neighbors that they felt not included, not consulted, very worried. So there's more pressure on farmers to actually consult and inform their neighbors. There's a precedent for future cases, and that could also be through different legal routes, of course, where you apply similar kind of reasoning. We see a lot of initiatives by different municipalities in the Netherlands that respond to these separate cases by saying maybe we should have a more strict approach in our municipality, where we just have as the policy that you cannot have lily fields closer than 50 meters to a residence, for instance. Much more pressure on the national government for a more national and harmonized approach, especially from the municipalities who say we cannot just do this alone, we need a national kind of uniform approach here. And a lot of pressure on authorization body to respond to these gaps that have now been confirmed also by the court. For instance, about the lack of research on neurodegenerative diseases and cocktail effects. So there's also more pressure on the authorization bodies to provide more, stronger evidence and answers to those urgent questions. So there's a lot happening, and it's not a final closed chapter. But I think that this analysis through communication science and legal analysis hopefully helps to reveal some further and more in-depth insights about what is happening here. And that was our presentation. So thanks for listening, and we'll be happy to send you the paper once it's a bit more finalized. Yeah, a bit further. Thanks.
Thank you so much. Extremely interesting, also from the interdisciplinary approach. Now we'll move from lawsuits on uses to lawsuits on authorization of plant protection products with Pietro Mattioli from the University of Liège here in Belgium. So you have the floor.
Thank you. Maybe I
use this computer then. Put it here.
Well, first of all, thank you, the organizers, for bringing so many different kind of backgrounds together for this workshop and the conference. And the focus of this presentation is more specifically on national courts that carry out a sort of technical judge's role when reviewing plant protection product authorizations. And just for give you a little bit of background and idea that comes behind this presentation is that there is much increasing legal contestation in the field of pesticide that has put the courts into spotlight. And mostly European courts has been the most active, and many questions have been raised beyond the role of courts in assessing decisions that are based on technical and scientific information. And so the problem is like the relationship between courts and administrators, which is really delicate. And much of this debate at European level has been informed by the Pfizer debate, and now this case law has developed over time. But the role of national courts has usually received little attention, especially from a legal perspective. But if we look at the plant protection product regulations, we notice that essentially, but as everyone knows, there is a two-level authorization process. So active substance at European level, but then we have a product authorization at member state level. And well, in this sense, national courts are competent alone, not European courts, to review national authorizations, ensuring that this wide discretion that national competent authorities enjoy in authorizing this product, which is also based on a technical and scientific information often submitted by the applicant alone, is subjected to judicial scrutiny. And this scrutiny, I believe, is essential, yes, for ensure the accountability of authorities, so administrators, but it's also important to align these decisions to the real objectives of the plant protection product regulation, which prioritizes health and environmental protection over economic interest. So in brief, during this presentation, I will raise what may look a really quite a legal argument, is essentially that there are recent developments at European level that may shape the role of national courts in reviewing plant protection product authorizations. And I will consider the implication of this possible development, especially in light of case law in the Netherlands that follow up directly from EU case law, and then some general reflections. So I will be really brief on the theoretical legal framework, but the idea is that there is always national courts, when they act within the scope of EU law, they act within a European framework, and so they have to respect the specific requirements. This can be procedural requirements, some standards, and in legal debates, the question is to what extent a European framework can have an impact on the national courts in light of a principle of European law, such as national procedural autonomy. And the Court of Justice has been often an active actor in shaping the role of national courts. Most recently, however, the role of the Court of Justice has shifted toward the deference. This not necessarily means deference from the judicial to the administrator, but also judicial deference. Essentially, this guided deference develops through the Court of Justice providing guidelines, blueprint for national courts when acting within the scope of EU law that are expected but not due to internalize when acting in the scope of EU law. And these specific guidelines has been often applied when national courts have to review decisions that fall within the scope of EU law. And clearly the pesticide is an area where this argument well fit. Now, this guided deference may emerge by looking at two recent cases of the Court of Justice. So I didn't expect to present in detail this case law as it concerns mostly the role of national competent authorities to conduct an independent scientific evaluation and assessment of a product when that assessment has been already conducted at a European level by another member state. So these are considerations that have an effect of mutual recognition and legal certainty are definitely relevant. But what I would like to focus about is about the possible judicial developments that this case law can bring. Because first of all, the court emphasized that applicants can submit the most reliable scientific and technical information to show that the member state scientific assessment lacks sufficient reasoning or justification. That scientific evidence can refer to both the endocrine disrupting properties of EU-level approval, but also to the product authorization conducted by another member states. And also the courts clarifies that when national courts conduct a review of this authorization, they have to take into account not only of the procedural element, but also the substantive one, including the scientific risk assessment, also when that assessment has been conducted by another member state. Now, this is the paragraph that essentially summarizes what can be identified as guided reference by the Court of Justice. And so essentially the argument that I would like to raise here is that the court emphasizes some sort of epistemic role and authority the national court should exercise in enforcing the plant protection product regulation by requiring a judicial review of plant protection authorization according to standards that ideally EU courts are also supposed to follow. Now, what are the standards that EU courts, let's say, ideally follow when conducting the judicial review of decisions where these decisions are based on a discretion which is really wide because of the economic, technical, or scientific foundation of this decision? Well, the court, first of all, clarifies that this discretion is not excluded from judicial review. This review is first procedural, so there can be look at the procedural elements, but also there can be a manifest error of assessment. So when the claimant claim that there is a manifest error of assessment, then the EU courts must verify whether the institution have examined carefully and impartially the facts of the individual cases on which the assessment is based, but also whether the evidence at the base of this decision is accurate, reliable, and consistent, as well whether it contains all the information that has to be taken into account to assess a complex situation, and so on. So essentially, the court conduct not only a procedural but also a substantive assessment of the scientific facts behind a decision, but also with a limit, so the court cannot replace their assessment of complex fact from those of administrators, which I think is the most blurry element of this general review. So, as I mentioned, the idea is to look at how this guided deference plays out in practice. So, if the EU court is asking national courts to review procedurally and substantively by looking at the merits and the scientific and technical information that underline a specific decision, how this is translated in practice. So, these two cases are actually the two preliminary cases that from which the Pan-Europe case law originated. And in these cases, the court focused mostly on the procedural aspect of this review. And he argues that the authority essentially the court annulled the decision on the procedural ground, but he remit to the competent authority, so the administration, the analysis of the new scientific element. So essentially the national court makes something that it's hardly contestable. It says the decision has to be annulled because you didn't took into account the scientific element, but it's not our responsibility to assess this element. This is the role of administrators. On the other hand, is a different discourse when national courts must review administrative decisions on the ground of the most reliable scientific data, which have been assessed, but according to the claimant, not properly assessed. So in this case, is more subtle the difference between entering the discretion of the administrator and remaining outside this analysis. So the Dutch court, what it does in these circumstances? So he annulled the decision because he noticed that procedurally the decision was not correct. But then, since the national competent authority made some additional clarification, taking into account the new scientific element, it kept the validity of the substantive element of the decision, which avoids the national court to assess the validity of these scientific elements. And indeed, when the national court is essentially asked to assess the question, should the national competent authority have reached a different conclusion based on the studies submitted by PAN, the court, what it does, use a sort of a deferential approach by first looking only at the procedural element, but also then making an assumption of correctness of the elements based on the procedural and temporal element of the controversy. So since these scientific data were considered by the court, then we assume they are right. But instead, if we look at what the Court of Justice expects the national court to do, we see that the national court, they should also look at the substantive element, entering into the reliability of this scientific information. Now, that said, these are some final considerations of this development. So I think, first of all, this case law of the Court of Justice is very significant because it allows much more legal contestation at national level concerning pesticide authorizations. This legal contestation in the Netherlands already had some effect. Indeed, the national court had an interpretation of procedural administrative matters in the Netherlands more specifically, assuming that the new scientific information can also be submitted in the objection phase. And the objection phase is part of the moment where national courts can also assume a new scientific information. And this does not end in the moment that the applicant submits all the information. And so these expand the epistemic basis and knowledge basis of the national competent authority decision-making. Then the current approach of the Dutch courts is unsatisfactory from the point that it does not enter the substantive element of the decision-making of the authorities, which is, I think, what everyone would expect in the future courts to do. And I also think that this lack of engagement with the scientific element is also due to the fact that often national courts lack the technical expertise to enter the scientific matter. I think in the Netherlands there is the possibility to record to an external body, independent, that can offer scientific advices. And I think this should be encouraged, the recourse to technical experts, to help courts address technical matters that are increasingly raising in front of them. And with this, I thank you for your attention.
Thank you very much also for the proposals, ideal food for thought for the debate. But now we'll continue in the same area, but in relation to the follow-up on the side of governance, I think, with Laurianne Allezard from Lund University, also about that relation between science, law and governance of pesticides. You have the floor for 15 minutes.
Oh, yes. Thank you so much. Thank you. Thank you for organizing this fascinating workshop. I'm learning a lot, and that's super great. Thank you so much. So today I'm interested into the national consequences of the Pan-Europe closure decision, what it changed, what it might trigger, and also what it will not change on its own, especially given the natural or traditional structural resistance of national courts. So it raised question that goes somewhere.
Presenter mode for this to work.
Okay,
Yeah,
that's great. Thank you. So it raised questions that go far beyond the collective authorization procedure for plant production products. It actually raised broader issues about the ability of national courts to effectively control the states in its regulation of pesticides. The states needs to be understood broadly. All three branches, executive, legislative, and judicial, are involved in the authorization and control of pesticides. So the key factor shaping pesticides authorization is science. Scientific data is the main real point of reference for limiting and ideally reducing the use of pesticides. But science is not law. And yet, science sits at the core of two major legal or even constitutional, depending on the country, frameworks. First, the precautionary principle, and more exceptionally, the principle of prevention. And second, the impact assessment done by the legislator before the adoption of the law. Now, while science is what triggers the precautionary principles and underpins impact assessments, it is also paradoxically what leads to their weakening in practice. It contributes to the current erosion or even the obsolescence of precautionary principle and to the often symbolic nature of impact assessments. Why? Precisely because science is not law, and because of that, judges may find themselves or claim to be disarmed. So in short, the main tool for limiting pesticides is not a legal one, yet it is the very foundation of legal mechanisms, and because of that, it often proves ineffective. So science sits at the crossroad of a struggle between the branches of power and potentially signals a constitutional shift in how we understand the separation of powers. Traditionally, science belongs to the political sphere. It is treated as flexible, open to interpretation, and non-binding. Courts have historically exercised self-restraint when it comes to how legislators or regulators use scientific evidence. But in light of these European developments, a key question now is who actually owns science within the different branches of power? Who has the competence over it? So Pan-Europe closer case answered a part of that question, specifically the division of competencies between national authorities and courts, but it did not resolve the deeper conflict between the branches of power over science. We could reframe this issue as follows. What is the nature and legal value of science? For policymakers, we can say that it is an option. For courts, it is an argument, and for national authorities, now, it is treated as facts. But then the real question becomes, for whom does science actually become binding, and how does it turn into a legal norm? So I assume, as you can guess, that EU pesticide governance is also a national and a theoretical, so universal, constitutional question. So I will examine that through 4 parts. First, we will have a very quick look on Pan-Europe closer case. After, I will try to show you the one of the most interesting case regarding the Pan-Europe closer. And after, we will have a more discussion about Constitutional Council and the Duplon law and the conclusions that we can have on that. So about Pan-Europe, I will not go deeper because I think it's enough now. But just a quick look about the limits of mutual recognition. So a member state is not bound by the scientific assessment of the reference member states. It can may depart from it. especially when the assessment is outdated or fails to reflect current scientific knowledge. So, no conflict with legal certainty because the court holds that scientific knowledge evolves over the time. Operators must expect reassessments. So it means that taking new scientific evidence into account does not violate the legal certainty. What is interesting here for me is that this case defines the duties of the national authorities and the role of national courts. So regarding the duties of national authorities, the authorities must verify the scientific basis of risk assessments, conduct an independent and updated evaluation, rely on the most reliable data, the latest international research, and must not automatically follow prior assessments. But the role of national courts are really interesting here because it precises what courts can do. Courts may review whether authorities consider relevant scientific data and must also review whether authorities comply with procedural obligation. But, and that is also a definition of the competencies of the courts, they cannot substitute their own scientific assessment, of course, and cannot rule on complex scientific facts themselves. So, the case precises what the national courts can do or must do and what it cannot do. So now regarding this French case, which was stated on the 3 September 2025, by the Paris Administrative Court of Appeal. So the court held the French state liable for failures by ANSES. The court found that ANSES failed to systematically re-examine authorization, did not rely on the most recent scientific and technical knowledge, so it's a breach of the regulation 1107/2009. This failure contributes to an ongoing ecological damage due to insufficiently assessed substances. So that is a novelty. And the court orders the state to re-examine all existing authorization within the 24 months. So we know that it's more complicated than that, but still, and ensure compliance with current scientific standards. So the link with Pan-Europe Closer. The decision is directly inspired by Pan-Europe Closer. It's kind of transposition into French administrative law. And the state must base decision on up-to-date scientific knowledge. So it respects the fact that the role of the courts is not to conduct its own scientific risk assessments. The court cannot evaluate risks. Instead, it identifies procedural failures and relies on missing or outdated scientific data as evidence. So it confirmed that Pan-Europe Closer sets a standard of diligence, and national courts enforce this through procedural review, not scientific substitution. So it's very optimistic, but if that's enough, can this decision actually create a standard for how judges deal with the best available knowledge available? No, because if we have a look on what the law can do, it's not enough. Administrative courts can therefore review authorization granted by the competent national authority, but they cannot prevent a legislative authorization or reauthorization of a pesticide. So their jurisdiction is logically limited by the content of the law and by legislative changes. So in an event of a legislative shift, like with the Duplon law, we might then expect that the Constitutional Court, and in France the Constitutional Council, to draw the logical and even philosophical consequences of Pan-Europe Closer. So the question now is whether Pan-Europe Closer can go further. Can it inspire a more coherent approach between administrative and constitutional judges through giving science a more binding role? As a reminder, in France, the legislator is subject to an obligation to rationalize legislation, which implies producing a systematic impact assessment. Since the 2008 constitutional reform, clarified by the Organic Law of 2009, impact assessments have become a constitutional requirement. But what this obligation does not say is how the legislator must actually use the data produced by the impact assessments. And that is precisely where the Constitutional Council could step in to define that standard. But of course, it has not done so, leaving the legislator largely free in practice. Before turning to the Constitutional Council review of the Duplon Law, it's worth briefly going back to the historical relationship between the Constitutional Council and science. So, as you can see on the screen, Laurent Fabius himself made this very clear. If we were to enter into a luxury of details, if we were to enter into the fact, then we will go beyond our role. We must not go into details that will be unnecessary. So that is the statement of this of the Constitutional Council. This is fully consistent with the lack of transparency and the limited engagement with scientific reasoning by the Council. Some example outside the field of pesticides. For example, the Adama case, which was released in 2019, the issue was the use of bond tests to determine whether young foreign nationals were minor or not. There was significant scientific controversy about the reliability of these tests. Yet, the Constitutional Council dismissed the scientific arguments raised by the applicants and upheld the government's choice despite the uncertainty and lack of alternative methods. So the pattern is clear. The Council avoids engaging with scientific debate and defers to political judgment even when science is contested. Another case which is really relevant regarding that question is this case about the sugar beets from 2020. This law very quickly reintroduced neonicotinoid and was justified by the government as necessary to protect the sugar beet sector and ensure food sovereignty. This justification was strongly contested by the applicant member of parliament. France was not actually at risk of losing food sovereignty. The measure primarily benefits a small number of large industrial actors, defending 5 major groups, 3 of which own 21 out of France's 23 sugar factories, and affected groups, like beekeepers, were excluded from consideration. So the applicant member of parliament presented robust scientific evidence, peer-reviewed studies, expert opinion like from the CNRS, long-term environmental impact, and the government in its observation, dismissed or ignored these arguments, relied on unsupported claims, and avoided engaging these conflicting scientific data. And the most interesting part of this decision was about the precautionary principle. It was really interesting. Clements invoked the precautionary principle, of course, to elevate the scientific consent to a constitutional level. And the government countered that the principle applies only in the case of scientific uncertainty. Here, environmental harm was already certain. So this argument effectively excluded the precautionary principle, reframed the issue as a purely political choice. Scientific evidence is treated as a persuasive but non-binding tool. The Constitutional Council does not arbitrate scientific disputes and defers to the legislature political judgment. So now this helps shed clearer light on the significance of the Duplon decision from August 2025. Seen in this broader context, the decision is less surprising. It does not mark a real break, but rather confirm the Constitutional Council consistent approach to science. So if at first glance this looks like a positive move by the Constitutional Council, the legislature deprived the right to healthy environment of legal guarantees, therefore it's unconstitutional, okay, it's a good move, but the Council accepts balancing approach between environmental protection and economic interests, grants broad discretion to the legislature, and intervenes only when safeguards are quite clearly insufficient. And yet, in doing so, it ultimately opens another constitutional pathway for a Duplon II. So in this case, the Constitutional Council already actually had two possible legal tools, which was the precautionary and prevention principles and the principle of non-regression. And yet, none of them were used, even noticed by the Constitutional Council. So it's particularly striking because the principles were extensively argued by the applicants' members of the parliaments, and they were very grounded with scientific data. And the precautionary principle just was exactly argued as the same for the government, for the French government. Like they act in a full knowledge of risk, so the precautionary principle does not apply here. Okay, and this issue is reframed as a political choice made in a context of urgency, in line with the Schmittian logic, which means that it's used to justify almost total deference to political discretion, because it's an emergency issue, the political decision can prevail. And I will finish with that. So the question is how far the judge is willing to go. So essentially, there is three possible approaches regarding the scientific facts. First, about the court can assess the reliability of the data, like the Constitutional Court in Germany does regarding climate litigation and COVID litigation also. It can also assess the compliance with the data, like the Czech Constitutional Court is doing that also. Which is the so-called rationality test, and also it can still going like in France with this mere awareness of the data. So we are stuck into this national imbroglio and about who has the power, who has the competence for dealing with science. Science has no clear status, and I will finish with that. About the climate litigation, which is quite relevant, I think, for its time out. It's time out. But yes, I just let you with this reflection about how the climate litigation before international courts raise the question of the responsibility of the state regarding the scientific knowledge available. So that is a great evolution, and it also reinterrogates how the national courts, but the state in general, can deal with this best scientific knowledge requirements. Okay, I will stop. Thank you.
Thank you, Laurianne. Fortunately, on sugar beets, we had the answer by the Court of Justice telling us that actually it's not legal in relation to primary law and the content of the secondary law to allow such kind of derogations. It shows the importance of the case law and of the position of the Court of Justice. And so that's the ideal transition to our last speaker of the morning, Alessandra Donati, from the University of Luxembourg, but she's also a referendaire at the Court of Justice of the European Union, and you are going to dig into that relation between judicial review, discretion, and pesticide regulation. You have the floor.
Thank you. And do you hear me well, or do I need a micro?
Please.
So I want to go back to the Cypermethrin cases. and present this case as an excuse, or better as an example, to discuss broadly on the extent of judicial review at the Court of Justice in pesticide litigation. Useless to say that I'm speaking on my own capacity and that these are my very personal opinion. I think Cypermethrin, my presentation is divided in 4 parts. There are no slides. I read it when the General Court and the Court of Justice gave these judgments, and I reread these judgments for this presentation. I find them very highly complex and maybe also difficult to understand, so I will focus only on key legal issues that for me are essential to have a broader discussion on judicial review. So first one, background to the dispute. As you might all know, Cypermethrin is an insecticide widely used within the European Union to combat crop pests. In 2018, EFSA issued an opinion considering that the use of Cypermethrin raised 4 main critical areas of concern. First, a high risk to aquatic organisms. Second, a high risk to honeybees. Third, a high off-field risk to non-target arthropods, meaning insects or invertebrates that might be involuntarily affected by the use of Cypermethrin, but we were not directly the recipients of that. And the lack of information on the composition of the batches of pesticides that were used by the company requesting the approval of Cypermethrin. And so in this context, EFSA was not in the position to ensure that those batches really reflective and representative use of plant protection product containing Cypermethrin. There was a meeting, as usual, in January 2019 of the Standing Committee. Within the Standing Committee, the Commission was not able to get the necessary majority to have the reapproval of Cypermethrin with several limitations be approved. And so it requested EFSA to make a statement on risk mitigation, which was really issued by EFSA in 2019. And EFSA said that only a risk mitigation measure reducing pesticide drift by more than 95% could really reduce especially the risk to aquatic organisms and non-target arthropods. In this context, Pan-Europe made a request for internal review at the Commission, which was rejected, and this opened the way to the case law before the General Court and then to the Court of Justice. So I move to the second part, which is the judgment of the General Court, and I will do it really briefly because I think it's more interesting to read this judgment in the lens of what the Court of Justice decided. So the General Court, in its judgment of February 2024, rejected the action made by Pan-Europe, mainly considering what? That in a context like the one at stake, in which EFSA identified several critical areas of concern and issued a recommendation of not renewal, the Commission is not bound by the results of EFSA. The Commission has to take into account the results. And here the General Court, I think, tried to make a step further, at least in the declaration of interest, by saying, in that case, the Commission can depart from the results of the risk assessment made by EFSA only if it demonstrates, and that's really the key word where the court will go back to it demonstrates that there are risk mitigating efficient and scientifically verified risk mitigation measures that can be adopted, showing that despite the fact that EFSA identified areas of concern for that active substance, the identification criteria of the active substance can be met. And so, in essence, that active substance in one of its representative use is not harmful for the environment and for public health. On this basis, and it was the legal basis, the General Court considered that in the case at stake, the Commission demonstrated that this was the case, that there were effective and scientifically proved risk mitigation measures, and so rejected the action. There was an appeal, and under appeal, the court set aside partially the judgment by the General Court, and we will see why, and went on by deciding itself the cases, considering annulling, partially and for the reason that we will see, the decision by which the Commission rejected the original request for internal review by Pan-Europe. In the framework, as I said, of I find really technical judgment, I think there are at least three main reasons why the court considered that the General Court was wrong in its judgment. The first one is that the General Court did not take properly into account the areas of concern identified by EFSA. And here I will go back to it at the end. We go back to, I think, one of the issues discussed this morning, which is the role of the judge in taking into account science. Because the court expressly criticized the General Court for not duly taking into account the areas of concern identified by EFSA, its own risk assessment. Well, the court says, yes, you, General Court, you clearly pose a nice principle saying that in a case like the one at stake, the Commission needs to demonstrate the existence of effective risk mitigation measures, but the General Court, as such, should have also duly and properly verified that the Commission had demonstrated, that the Commission had complied with its obligation. And two examples. The first one concerned the critical area of concern relating to the lack of information on the representativity of batches. In the judgment before the General Court to reject Pan-Europe's argument, the General Court relied mainly on an email sent by the rapporteur member states that confirmed that even that at the level of member states there had been some checks. Some studies were available, some studies permitted to say that despite the opinion issued by EFSA, there were some data. And these data gaps concerning the representativity of batches could be filled. Faced to this argument, the court said this is not enough to comply with the duty of the General Court to check carefully and to state reasons, because the court did not explain why, the General Court did not explain why it gave precedence to an email sent by a rapporteur member states over the opinion issued by EFSA, and did not demonstrate why these risk mitigation measures were effective. Another example concerned the critical area of concern identified by EFSA relating to non-target arthropods. Again, in its claim before the General Court, Pan-Europe argued that the Commission did not sufficiently take into account the area of concern, and the General Court replied to this argument by saying that a safe use of Cypermethrin for arthropods was identified in the steering committee. And at the end of the day, it was for the member state at national level to identify risk mitigation measures to be sure that those measures are effective. Once again, here the court considers that the reasoning of the General Court is erroneous. First, because in no way a word said by a member state in the standing committee, being it in the sense of affirming that a certain substance is safe or it's not safe, could overcome or could have a precedence over the statement and over the risk assessment by the EFSA. And in any case, and that's here for me the second point of the relationship of judicial control, not vis-à-vis the risk assessor, but vis-à-vis the member states. You all know that in the framework of plant protection product, member states have a role to play at the level of authorization of the plant protection product, but does not mean that this delegation of the Commission can make a blind delegation of power to the member states. The Commission shall bear its own responsibility at the level of the authorization of the active substances, and the General Court shall control that the Commission has established the existence of such measures. So, and this was for the first point, the first failure, lack of, by the General Court to take into account the critical areas of concern. What the Court says actually is the General Court adopted a soft, very soft standard of judicial review, merely based on the assumption made by the Commission reflected in the decision at stake, and failed to motivate and failed to duly take into account the underpinning scientific, but also the proof behind the arguments of the Commission. Second mistake, if I can say so, is an error in law. The Court considers that the General Court erred in law when interpreting the main provision of dealing with the authorization of active substances, which is Article 4 of Regulation 1107 of 2009. Because the General Court considered that this provision only relates to active substances. And by following the interpretation of the Commission, the General Court considered there's a sharp distinction between the approval of active substances at EU level and the approval of plant protection product at national level. And so in its judgment under appeal, the General Court said, if we are at the level of European Union and we look at the authorization of active substances, we don't care about final products. And the court said it's wrong. And it's wrong because, yes, of course, if you read the title, even the title of Article 4, it deals with the approval of active substances. But active substances need to be approved in concreto, which means you need to look at the representative of at least one representative use of one plant protection product containing that active substance. And only if that one representative use of one plant protection product meets the requirement criteria, so the active substance can be authorized. Third and final main failure found by the court in the reasoning of the General Court relates to the failure by the General Court to check properly if the Commission had established the Cypermethrin had no long-term toxicity effects. One of the main arguments raised by Pan-Europe in the case before the General Court was that, again, the Commission did not take into account that the Cypermethrin might have long-term effects, long-term toxicity effects. To validate, to uphold the reasoning of the Commission, the General Court was again, according to the court, too soft in its reasoning because it said that there's no mention to toxicity long-term effects in the report of EFSA. There's no reference in the national report made by the rapporteur member states. This means, according to the General Court, that this is okay. And so Cypermethrin has no long-term effects. And the court said there can be no presumption. According to the precautionary principle, the authorization of active substances cannot be made on a presumption. You need a full proof. You need to prove, the Commission need to prove, that active substance is not carcinogenic, neither today nor in long-term effects. Second, the General Court, to reject Pan-Europe argument, said that we don't need to check more because these products, the product containing Cypermethrin, are already authorized in the market. And because in one of the confidential documents which are annexed to the joint to the case, there might be an explication on why, or some data explaining that Cypermethrin has no long-term effects. Again, the court considers that these are not good arguments. First, there's no relevance to the fact that a product is authorized at the level of member states has no impact on the procedure for the authorization at the EU level of that active substance. Last point, and the fact that there might be a confidential document explaining that Cypermethrin had no carcinogenic effect is again irrelevant. The General Court was too shy, and the word used by the court I think is significant. The court says the General Court should have made a more vigorous check on that dossier, ask to have access to the dossier and really establish if the Commission had proved the existence of such measure. So at the end of the day, and then I'm moving to my fourth and last point, what can we say about this judgment? I think these two judgments are a good, even an extreme example to see how different can be the standard of judicial review. Not only in this case before General Court, the General Court really adopted a very soft, especially soft, standard of judicial review. And the Court of Justice asks the court to do much more in the sense of really checking the plausibility and checking the existence of proof and checking that the assumption made by the Commission in the contested decision were backed up by facts and data. So, and this brings us to the topic of judicial review, to the intensity of judicial review, which for me is one main theoretical aspect. We remain today in the framework. We can discuss it, but we remain today in the framework of an error of assessment control, which means that the Court of Justice mainly controls if the claimant has proved that the institutions has made a main error of assessment, which means misuse of power, procedural errors, failures to state reasons, methodological errors, and failures in the plausibility. Plausibility in the assessment made by the commissions, plausibility in the one of the elements used by the risk assessor. We could discuss it. We could discuss is, I know, I read, Antoine, one of your last paper in which you say, and you seem to support that opinion, that the Court of Justice should go far, should really assess the scientific basis of that opinion. Some others might say no. What I want to say here is that I cannot take a position on that. It would be hard. But what I want to say is that in practice, for me, there's also another element which has an impact on judicial review. And this is my own personal contribution to the discussion, is what I can see when a case, I'm not working on pesticides cases, but the problem arises in all kinds of cases which deal with complex scientific assessment. Could be pesticides, litigation, competition cases. The problem is that despite the theory, which is very important, I think we need to have these kind of events. We need to have a discussion. We need to bring more awareness also within the institutions to know which are the limits. I think for me, there are two elements that have an impact on the intensity of judicial review. The first one is might be obvious, but I swear it's not. It's the readability of claims, especially in complex issues. The easier a claim is to understand, the more the person, the referendar or the judge reading it will be keen to understand more and to go further. I think it might really seem obvious, but it's not. Because the most difficult part of my job is really understanding in a good way what parties are saying. And I'm not saying that because the lawyers are not good, but because the claims are more and more complex, are more and more technical difficulties, and per people within the court reading them, they do not have the same expertise that you have on the topic. So I think the challenge is to find a balance to be exhaustive, but also translate in a comprehensible and readable way to the people reading you, which are not scholars interested in pesticides, which are people working on EU law who know the main concept of EU law well, but you do not necessarily know the technicalities of that issues. Which means for me that to show, for example, a manifest error of assessment, you need to give the keys to the people reading to you. And the keys means showing for me an imbalance, an impair of rights that can give the people reading again an index of an idea that might be something behind. Because if the standard of judicial control do not change, we can assess the substantive matters where we do so by procedure. So I will never not be able to check directly if F's assessment is wrong, but if the claimant gives me the keys to notice that there might be key data missing or that the commission has misinterpreted that, it will be easier to do that. And on that, I think one of the procedural main obstacles is the length of claims. I know that it's a long story. We have a limitation of 50 pages, which is interpreted in a different way for different areas. There are more and more, I would say, an openness by the judges to give it in a flexible way. The idea of this limitation for me is key, is to avoid having 1,000 pages of claims, which is useless. But on the other hand, I'm not sure that limiting, for example, on pesticide litigation to 50 pages is a good argument, because maybe it would be easier to understand topics in 50 pages rather than in 50 pages, very complex. And the second point, which for me has a concrete impact on judicial review, is the expertise of the judges. which opens for me the door to some key questions which have a more theoretical scope. The first is, shall we go for specialized chambers in environmental law? We are not there. As you all know, the General Court, there's been a recent reform in which we received some new competencies in preliminary rulings, so I don't see any venue, at least today, for reform. There are an increasing number, a great number of cases in environmental law, especially pesticides litigation, but I think that in terms of workload, this could explain or justify the existence of specialized chamber. The second one is the possibility of assigning cases by connexity, which has also, for me, a huge impact on the outcome of the case. Which I mean is that, as for all you to know, when a case arrives at the General Court, for example, the case is assigned by the president to chambers, one of the 10 chambers. And then the president of the chamber assigned the case to one judge, a formation of, usually at the beginning at least, a formation of 3 judges, in which he gives that. So the problem is that if all cases go by connexity, for example, pesticides case, all glyphosate cases go to the same judge. All cases on endocrine disruptors go to the same judge, which is good on one side because it allows that judge to have more expertise and to fill the gap of knowledge that I was mentioning before. But what about if there's not a good understanding? Or what about bias are everywhere? So open question. And very last point for me is on the opportunity, but I will leave you with a question on the production of an expertise. Could be a private expertise or an expertise asked by the Judicial. The court has the possibility to ask expertise. I'm not aware of any case, maybe. But what about that? It's a recurrent topic I've been discussing also with my colleagues. But I will also be happy to hear your point on that. Thank you very much.
Thank you so much. Time for the discussion now.
Many questions I see already. Please.
Maybe we take 3 together. 2 questions.
Okay, thank you very much for... yes, I'm Elvira Bacci from Sant'Anna School from Pisa. And I have a question that maybe is more for Laurianne, because she was talking about the French area. And in September 2025, there was a decision taken at the administrative court in France that I thought it was maybe in line with what you were discussing. And here we saw that they gave some deadlines for the state to act in the field of pesticide for checking the renewal of these active substances. But then we saw in March, when the 6 months expired, that no action was taken. And here my thought was courts intervened, but there was no effectiveness in the end because no action was taken. And that's it. Yeah.
Yeah, thank you for the great presentation. I have a first question to Edwin and Emma. I would be interested in hearing a bit more about the legal pathways that have been used by these citizens to bring the cases to local court. I don't know, since there were 6 cases, I had this impression that they were made at a very local level. And I have another question, maybe more for Alexandra. It's a really open one, and I would be interested in hearing Antoine's view on this. During the last presentation, I couldn't stop thinking about the titanium dioxide case, and I'm speaking under the control of Natasha because she knows much better than I do. I think this is exactly the opposite. There were a lot of criticism about the court really going too far into the scientific assessment and replacing the role of an agency. Isn't it the risk that if we go down that road that we end up with the same on pesticides? Yeah, what is your view on this? And yeah, very open question, in fact.
Thank you. A question to the Wageningen colleagues. Why do citizens always do civil cases on lily fields? Is it the Dutch habit of being very directive, so they go to the farmers directly? Because they could also do a case on the transposition of the Sustainable Use of Pesticides Directive that normally should prevent direct exposure to pesticides others than low-risk substances and biocontrol. And then the second question is, how do judges deal with the science? Because it's true, it's about neurotoxic assessment, but EFSA says no, but we do some neurotoxicity assessment. So that's, and I suppose they do it in different ways. Is there a consistency between the different tribunals? And it relates also to what Alessandra was saying about how do you use science? Because we, for the first time in the glyphosate case we have now at the General Court, we produced a scientific expertise that we joined to the case, and we'll see how it will be taken into account by the judges. But yeah, I would be curious to know how the Dutch judges deal with this. Thank you.
Thank you. I suggest the lilies first.
Team Lilies. Thanks for the question. So these indeed are civil proceedings, and it's. I was looking for the English translation. They say it's summary proceedings, where just like, for instance, if my neighbor would want to build a shed and you want to block that, you would start at this type of case, and it's the same for the lilies. So it only binds the two actors then and for that specific field, which makes it quite confined. And then that relates to your question, Martin, like, why do they take this route? Because in the end of the outcomes, it's really quite narrow. I think in the Netherlands at the moment, there's a lot of different strategies being used. So yesterday we also spoke about this Flemish case where there was the the appropriate assessment question. There was a case brought in the Netherlands by an NGO against the decision by province to not require appropriate assessments for lily farmers close to Natura 2000 sites. So again, lilies, but not civil cases. So it falls outside of our scope, but it is happening. And in that case, actually, the judge said that there should be appropriate assessments done by these lily farmers before they start using all these pesticides. And then, of course, it becomes extremely difficult to prove that you're not having a negative impact on these sites because they're already in a very poor state. They use a lot of pesticides. It's not for food security or things. So it's very tricky. That was last year. Last year, the province said we're not going to enforce anything yet because all of these farms already have their crops. This year, they said they would enforce it. They requested Wageningen University to test how an appropriate assessment could work for pesticides. Wageningen said, we don't know. And now the farmers say, we also don't know. And the province said, we will definitely enforce, but maybe not yet. So it's a very crazy, there's so much happening now. We focus just on the civil case because we think it's so interesting how the farmers themselves and the citizens in this very local proximity frame risks and how judges deal with that. In terms of the scientific dealing, that's the last part, and then I'll round up. The scientific assessment, within these type of cases, the judge only looks at the very, at the science that the parties bring in. Part of the science that the parties brought in is quotes from the CTGB, for instance, saying that actually we don't really know what the impacts are of the cocktail effects. So then the judge can say, well, if they don't know, like how can the citizens trust that actually there are no effects? So yeah, and then the farmer said we trust the CTGB, but if the CTGB even sees that there's these gaps, it's a difficult thing to win. So yeah, a lot of things happening.
But just a detail: the defendants, are they the farmers or the municipal authorities?
So the civil cases are always a citizen versus a farmer, or at least a pesticide user. But there are a lot of cases brought, especially by NGOs, that are more against, for instance, the province for not taking actions or for not requiring appropriate assessments. These are brought by NGOs, usually. These are the case that we focus on is citizen versus farmer.
Thank you. Do you want to say a word, or Alessandra?
Tricky question, yeah. I think, Antoine, we might not have the same view on that. In the titanium dioxide case, I do think that it's an opposite case in the spectrum of possibility on which the General Court could do. And so I think that within the Cypermethrin case and the titanium dioxide case, maybe the good answer is in the middle in terms of intensity of judicial review. It was too soft or maybe too much. And I think for me, my personal opinion is that the General Court was too much. Too much in the sense that the General Court really tried to replace the scientific assessment. What you could say, and I agree with what you said in your paper, is that what the court said under appeal, so sanctioning the General Court, at the end of the day, what the court proposed is not very far from what the General Court did in the first grade, because the court did not follow the opinion of the Advocate General. The Advocate General proposed to sanction the General Court and to set aside the judgment. The court said, okay, the General Court was wrong because it replaced its own scientific assessment on titanium dioxide to the one made by the European Chemical Agency, but did not follow the conclusion of the Advocate General and sanctioned the Commission at the end of the day, the European Chemical Agency, for not taking into account all the proper documents. So it brought back the scope of judicial review to procedure. So what is sanctioned is not a failure. The General Court cannot. And I think it's okay. We cannot, because we do not have the tools to making a new scientific assessment. We can check if it's not wrong. The problem is that how can you check if something is wrong in the scientific assessment if you have no scientific clue of what you are saying? So it's a really tricky question. I don't have a straight-cut answer, but yeah.
So do you want to answer?
Yeah, very, very briefly, yeah. I think what you said in the beginning about the fact that there is a procedural problem, there can be procedural reviews, there can be review of problems of reasoning, then methodological questions, and then plausibility tests. That's my point. I'm not saying that they should be able to redo the assessment all over again, but take seriously this plausibility test. And in this case, as far as I can tell, I mean, I'm not a scientist, but what the General Court said was just good sense. It really seemed like common sense. It really seemed like ECHA overlooked something important, and the fact of that the Court of Justice decided to just cloak this and say, no, this is just a methodological issue, to me is a bit shy and I think it should stand up for its own case law. It didn't require more than just applying the real test that it itself created, and it's retreating from it now. That's what I'm fearful of, and I agree that sometimes, of course, it means that the industry can win. Yeah, of course. Yeah, well, I think we should accept that too. There's no reason why science should only go one way.
There was also a question for you, Laurianne, from Sweden, where actually in the tribunals there you have experts, actually.
I think the question
scientific
was,
ones.
Yeah, but I think the question was about France. Yeah.
Yes,
but I think it was one of my points during my presentation. So I don't know what to add now, except that yes, the government has lodged an appeal with the Conseil d'État, so waiting and see. Wait and see, yeah. I don't know what to add.
Okay.
Yeah.
Other questions? Yes, we'll take the two of them.
Thank you. Natasha Chingotti from Foodwatch International, previously with the Health and Environment Alliance. I want to come back on the titanium dioxide case, actually, because I think it's a very interesting case for everything we've been discussing in terms of judicial review. And in my sense, the question of, should the judge go further in the scientific assessment or not, also necessitates to have a look at whether the judge understands the nature of the scientific assessment system as it works today, and the fact that industry is in fact providing the first data in the system. And often the problem that we will see when we're working on carcinogenicity classifications, pesticides per review, is where industry actually does not provide data or does not provide good enough data for the regulator to do the job. And where I see the titanium dioxide case as a very big threat is that actually this case started because industry never provided the regulator with good enough data to do the job. And then what happened in the realm of the European Chemical Agency is that the regulators had to do choices about how to use the data they had. And actually, I still think they did a good choice with their carcinogenicity classification. And now we are in a situation where actually the court went very much into scientific assessment that it totally doesn't master on nanoparticles, made quite strong statements, and actually managed to annul a judgment, which annul a classification, which in my view is still valid. So I think there's also a risk in the sense of discouraging further regulators in a context where they're already struggling to do their job and actually put forward hazard classifications and decisions of risk assessment. And I think in this debate, that's a bit, the big picture discussion for the future. So I wouldn't, rush into advising that the courts go more and more into the science. Actually, I'd be very careful. And on requesting scientific expertise from the outside, I would also be very careful because, of course, the question is, where does it come from?
So thank you for answering actually the questions that were raised.
I just wanted to but I agree with you on the intrinsic properties, but that's a legal question, and the court got it wrong. But it was on legal side it got it wrong to me, not on scientific. But anyway, so yeah, Caroline.
Hello, I'm a lawyer from Germany, and I'm representing NGOs in lawsuits against product authorizations. We have the right to attack authorizations in Germany only since 2 years, so this field is quite new in Germany. And what I see is that apparently it's the ECJ judgments are implemented very differently in the different member states. And so my question to Pietro and Laurianne is whether you also looked at the implementation in other member states. So you looked at the Dutch implementation, and you looked at the implementation of French from French courts, and I know these judgments, and from a German perspective I can say, wow, the Dutch and the French courts, they're doing a great judicial review we can only dream of in Germany, because the German courts are still on the position, also after the closer judgments, that they cannot make any judicial review if the risk assessment comes from another the zonal rapporteur member states. So they can say they could only depart from the risk assessment by the zonal rapporteur member state if there would be in Germany specific environmental conditions that do not exist anywhere else in the zone. So which basically excludes all criticism of authorizations. And my impression is that it's a little German bubble, this case law, which I cannot find judgments from other member states that would confirm this interpretation of the closer judgment. And so I would be very interested in your view, in your experience that you have with judgments from other member states. And I'm of course very happy to provide you with German judgment, which are all very recent, and help you with the translation or interpretation. Thank you.
Thank you. So how panoramic is your research? Pietro?
First of all, thank you for offering to have access also to German case law, because in my personal experience, one of the challenges most of the time in looking at different jurisdiction is when you don't come from that jurisdiction to access the specific case law. I did it from the Netherlands because it's really clear and organized case law, and also is directly related to the Pan-Europe case law. I did it from Italy, and it's also really limited, the case law specifically on product authorizations, and shortly also in Belgium. But I presented only on the Netherlands. I can say that for what I think, and this is also something, there is an association of administrative judges in Europe that is called ACA Europe. I went to one of their seminars, and one of the problems was like, or the technical assessment, the judicial review of technical matters. And one of the problems is that is strictly related to the constitutional characteristic of every member states. For example, Germany still stick to the fact law divide. And so law is the matter of the courts when all the facts should remain outside, or they can enter the court only when they are incorporated within legal standards. So they said that this was my impression, they respect legal standard much more than accepting facts. But then you have, for example, Finland, which is an exception because they even incorporated expert within the courts to handle the specific scientific elements. So an expert is becoming a judge as equal as a legal expert judge to assess the scientific assessment. And the experience of the Finnish case law was like, we enter really into the details of the scientific elements because our approach to different elements of the controversy is different from other jurisdictions. So that's why I focus on these, and I found the most critical, but I think the complexity of different jurisdictions is that they offer different kind of approaches. Despite, I think, voilà.
And it's also related to the composition of the tribunals up there in northern countries, I think. Laurianne?
Thank you, Caroline, for this insight from Germany, and I'm really, really interested to know more about how it works there. For me, on my side, I just focused on France because the focus of my research was to understand how science is expressed into the judicial reasoning. So pesticides was one of the example, and I compared German jurisdiction, but also Czech and Hungarian jurisdiction regarding how they assess scientific facts and how they can constrain the legislator and the regulator. So I cannot give more regarding your question, but I think it's so interesting, and the comparison could be so, we can learn a lot from that, I'm sure. Yeah.
Thank you. And now the last question. Is there any or an answer? Yes.
Yep. Yes, this is not a question, but rather an observation. I think that next to the complexity, the jurisdictional complexity and variety, what emerges from the discussion of the Lilly cases is, of course, that there may be also quite a different. There's also a variety of disciplines, so administrative law judges versus civil law judges. And civil law judges are quite a fascinating example. It seems that they are less constrained by administrative regulatory frameworks and rationalities, and are therefore perhaps sometimes able to offer a perspective on risk and science which comes in from a very different angle, and perhaps an angle that is closer to citizens than it is to the administrative state. And that might be a value. So that's quite an interesting observation from this discussion.
The importance of the general standard of care and the importance of main principles and generic approaches to health protection of ecosystems and human health. I think it's a good conclusion for the moment.